Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where are we today? Come on, you guys know where we are. We are at our Idaho studio right here at North Idaho Arms, beautiful Post Falls. America, I need to talk to you about a lawsuit that's kicking around in the state of New York that has the potential to be an incredibly dangerous lawsuit because it would serve as a blueprint for how other states that are hell-bent on civilian disarmament can drive many firearms manufacturers out of business. I'm not making it up. We'll go through the court's ruling so you can understand. So today, let's spend a few minutes and let's talk about the gun industry's most dangerous lawsuit right now. Okay, America, here's what we're talking about today. We're going to talk about a lawsuit that stems from a horrific mass shooting outside of Buffalo, New York, back in May of 2022. This is a case where, rather than going after the crazed maniac who, of course, committed the horrific acts, we instead are going to go after manufacturers of certain components that were used to execute that mass shooting. Now, even though these items were all banned in the state of New York, shockingly, those gun laws did not stop the crazed individual from committing these acts of violence. And of course, it has not stopped people from suing. The case that we're going to be talking about today is entitled Salter versus Meta Platforms, but what we're going to be focusing on is the defendant Mean LLC. They had, in fact, manufactured a component that can be inserted into what the state of New York refers to as high-capacity magazines to essentially plug the magazine at New York's limitation du jour, which was 10 rounds. To give you a more specific description of what they are doing, the court's opinion that we'll be focusing on today summarizes it as follows. The instant appeals concerns in particular defendant Mean LLC, which manufactured and sold the magazine lock system on the Bushmaster XM15 semi-automatic rifle the shooter used during the incident. It is undisputed that the shooter removed that lock, thereby illegally modifying the firearm so as to allow it to have a detachable high-capacity magazine not permitted by New York. Okay, so you sit there and you go, okay, so they're making a product to allow other products to be brought into compliance with New York law. Someone then decides to illegally remove that product, and we want to now hold the product manufacturer liable. Is that right? Yeah, that's right. That's what this suit all is about. And as the court pointed out, despite the lock's alleged performance, Mean also included instructions in its packaging and its website on how to remove the lock, thereby allowing the shooter to illegally modify the firearms and remove the lock in order to load large capacity magazines, like the one the shooter used on the day of the shooting. Now, for those of you who might recall the very important case that came out of the United States Supreme Court recently of Smith & Wesson v. Mexico, you will recall that there is a large piece of federal legislation known as the PLCAA, the Protection of Lawful Commerce in Arms Act. And one of the things that the PLCAA specifically stands for is hey, listen, if we have intervening illegal third-party activity, we cannot hold the manufacturer responsible for that illegal activity. It would be akin to being able to sue the Ford Motor Company because some drunk driver was driving a Ford when he injured somebody in a drunk driving accident. But there are exceptions, okay? There are exceptions to that statute, one of which is if the manufacturer absolutely positively knew that they were engaging in activity that would have been deemed unlawful by state or federal law. And this is where the hook comes in, America, and this is why you have to pay very careful attention to the types of Consumer Protection Act laws that are being passed in your state. And with all of these consumer protection laws, you will have, like in New York, these large sections of statutes that are called general business laws. And they basically outlaw shady business practices, such as false advertising, such as guaranteeing a product for one purpose when you know, in fact, it cannot meet that purpose. And what the state of New York is arguing here is that, hey, Mean was saying that they can absolutely positively permanently plug these magazines. But in reality, there was a way to unplug these magazines, and therefore they engaged in false advertising. And the hook that they're using here is that the plaintiffs, knowing that these magazines could be altered, but advertising that they were permanent, engaged in the act of false advertising. They knew they were engaged in the act of false advertising, and because they knew they were violating that law, the PLCAA does not protect them. The problem for the defendants here is the New York State Supreme Court, 4th Judicial Division, has agreed with them because they have ruled as follows. With respect to whether Mean knowingly violated General Business Law Section 349 and 350 for purposes of 15 United States Code 7903, we conclude that the allegations in the complaint are sufficient to withstand the motion for dismissal. In the context of these motions to dismiss, plaintiffs' allegations that Mean knowingly and falsely promoted its lock with claims that it would bring customers' rifles into compliance with New York law are sufficient to permit application of the predicate exception with respect to the violation of the general business law. So I want you to understand what they're saying here is that the company claimed that by using their product, they can bring these magazines into compliance, which, by the way, when the product was properly used, the magazines were, in fact, in compliance. But because the product could be removed by somebody with nefarious intent, the state of New York is now claiming that this constitutes false advertising. And because it constitutes false advertising, and Mean was aware that they were engaged in that act, the PLCAA does not exist, and therefore a lawsuit against not the magazine manufacturer, not the firearm manufacturer, but the manufacturer of the plug and the magazine is now being sued by the families of all of these individuals who were affected by this horrible incident of gun violence. But what I need you to be aware of, America, is that this is not unique to New York, Washington State, Oregon, California, Illinois, Maryland, New Jersey. Many other states have passed all sorts of consumer protection laws, which on its face looks like they are in fact designed to protect the consumer. And undoubtedly, in some instances, they are exactly that. But many of these laws were put in place to go after manufacturers of products in which state government does not believe in. In Washington, for example, if you are a gun store and you decide that you're going to violate the state law on assault weapons and or high-capacity magazines, even if you have local law enforcement or local prosecution that does not want to prosecute that, the state of Washington, through the Attorney General's office, has the ability to fine a gun store $7,500 per violation, essentially running them out of business. Many of these consumer protection laws are there to expand government's reach into private industry, to regulate the industry beyond what the constitutional limitations are. So, America, that is why this case and this precedent serves as a very, very dangerous playbook for those states that are hell-bent on running gun companies out of their state and disarming their civilians. The case, once again, is Salter versus Meta Platforms. I want you to focus on the complaint as it relates to Mean LLC. We're going to go ahead and link up the opinion down below so that you can geek out on it for yourself. You don't have to take our word for it. Again, this case has now survived a motion for summary judgment, motion for dismissal. It moves on to arguments on the merits, and this becomes very, very dangerous. Listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From North Idaho Arms here in beautiful Post Falls, Idaho, thanks for watching and stay safe.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They pave the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense, so from a fist to a firearm, from a a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.